Right now, more than 100,000 people in Louisiana have already voted in an election that their own governor decided to suspend. Not before voting started, not before a single ballot was cast. After. Some of those voters mailed their ballots weeks ago. Some stood in line and cast an early vote in person, confident their vote would be counted the way every vote in American history has been counted, as final the moment it goes in the box. Then, in the span of about a week, a Supreme Court decision came down. A governor declared an emergency, and a primary election that was supposed to happen on May 16, 2026, got paused in the middle of active voting. If you have never heard of a state pulling the plug on an election that was already underway, that is because it almost never happens, and the fact that it happened here, in these specific circumstances, is exactly why you need to understand this story before the next headline flattens it into something simpler than it actually is. I am going to walk you through the exact timeline, hour by hour where it matters, so you understand precisely what happened, what it means if you live in Louisiana, and why legal experts across the country are calling this one of the strangest and most consequential weeks in recent election law. Before I get into the timeline, if you want to know the moment something like this happens again in Louisiana or anywhere else, subscribe and turn on notifications right now, because stories like this move fast, and by the time cable news catches up, half the important details are already old news. I track election law and Supreme Court rulings the moment they land, not the moment they trend. Let's get into exactly what happened. Here is the setup you need before the timeline makes sense. Louisiana had been fighting two lawsuits over its congressional map for years. One lawsuit, filed by black voters, argued the state's map diluted their voting power by giving them only one majority black district out of 6 seats, despite black residents making up roughly a third of the state's population. That lawsuit succeeded, and a federal court ordered Louisiana to draw a second majority black district. The state complied, passing a new map known as SB 8, one that ran a district roughly 250 miles across the state, from the northern edge near Shreveport down through Baton Rouge to reach enough scattered black population centers to form a second majority black seat. But almost immediately, a different group of voters, led by a plaintiff named Philip Callais, sued over that same new map, arguing the state had used race as the predominant factor in drawing it, violating the Equal Protection Clause. That second lawsuit, Louisiana versus Callais, made its way all the way to the Supreme Court, and on April 29, 2026, the court ruled 6-3 that Louisiana's map was an unconstitutional racial gerrymander. Justice Samuel Alito wrote the majority opinion, joined by Chief Justice Roberts and Justices Thomas, Gorsuch, Kavanaugh, and Barrett. Justice Elena Kagan, joined by Justices Sotomayor and Jackson, dissented sharply, warning the decision guts the primary legal tool minority voters have used to fight discriminatory maps since 1965. That part of the story on its own would already be a major legal event, the kind that gets analyzed in law school classrooms for the next decade. But it is what happened in the days immediately after the ruling, not the ruling itself, that turned this into something almost unprecedented in modern American election administration. The first segment of the timeline is what usually happens after a Supreme Court decision, and why that normal process did not happen here. Under the court's own procedural rules, specifically Rule 45.3, a decision does not become final and enforceable right away. There is a standard 32-day waiting period before the court sends its judgment down to the lower courts for enforcement, built in specifically to give the parties time to file a request for rehearing before anything becomes irreversible. This is not some obscure technicality nobody uses. It is the standard operating procedure for essentially every significant Supreme Court decision, precisely because the justices themselves recognize that finality has consequences, and a losing party deserves a real window to ask the court to reconsider before lower courts start rewriting laws, redrawing maps, or reopening cases based on a decision that could theoretically still change. In the ordinary course of business, that 32-day window would have meant the Callais decision, handed down April 29th, would not have become final and actionable until roughly the end of May, well past Louisiana's scheduled primary date. That timeline would have left Louisiana's already scheduled May 16th primary completely untouched, running on the existing map, with everything sorted out for the next election cycle instead, the same way redistricting disputes have typically been resolved for decades after an election concludes rather than in the middle of one. That is not what happened. The second segment is the part of this story that surprised even people who follow the Supreme Court closely. Louisiana asked the court to skip the standard 32-day waiting period and finalize the judgment immediately. The court agreed, effectuating the ruling on May 4, 2026, less than a week after the decision was announced. Justice Kagan's dissent did not stay quiet about this procedural shortcut. In a separate filing tied to the emergency application, the dissenting justices pointed out that the majority was bucking its own usual practice, and argued the decision to rush the judgment forward was tantamount to greenlighting whatever Louisiana intended to do next with its ongoing election. That warning turned out to be exactly right, because Louisiana's governor had already moved before the court even finalized anything. The third segment is the governor's own action, and this is the part of the story that actually stopped the election. On April 30th, 2026, the day immediately after the Callais opinion came down, Louisiana Governor Jeff Landry issued an executive order declaring an emergency and suspending the state's May 16th primary election, giving the legislature the ability to completely redraw the congressional map before voting could be finalized. Think about the sequence for a second. The Supreme Court had not even formally finalized its own judgment yet when the governor moved to pause an election that was already underway. The primary in question was not some hypothetical future contest. It was live. Ballots were already in circulation, voters were already casting them. And in the middle of that active voting window, the governor's emergency order effectively froze the process, with the stated justification being that continuing to run the election on a map the Supreme Court had just ruled unconstitutional would create an even bigger legal mess than pausing it. The fourth segment is the number that makes this story land differently than a normal legal dispute over district lines. As of May 4th, 2026, when the Supreme Court's decision was formally finalized and effectuated, more than 100,000 Louisiana voters had already cast early votes in the primary that was now suspended. 100,000 people had done everything right. They had followed the rules, shown up or mailed in their ballots during the legally designated early voting window, and trusted that their vote would be counted as part of a completed election, the same way it always has been. Picture a retired schoolteacher in one of those affected parishes who took an afternoon during early voting week to drive to her parish's early voting site, waited in a short line, marked her ballot for the candidates she had researched for weeks, and drove home feeling like she had done her civic duty for this cycle. She has no way of independently knowing right now whether that ballot will ultimately count toward a rescheduled version of the same primary, get folded into a different contest under a redrawn map, or need to be recast entirely. That uncertainty is not a hypothetical inconvenience. It is the actual position more than 100,000 real voters are sitting in tonight. Instead of a completed election, those votes are now sitting in a kind of legal limbo, cast under a map the Supreme Court has ruled unconstitutional, in an election the governor has suspended, with no immediate, universally agreed-upon answer for what happens to them next. If you are one of those 100,000 voters, or if you know someone who is, the honest answer right now is that the legal process for resolving what happens to your already cast ballot is actively being litigated, not settled, and anyone who tells you with total confidence exactly what happens to your vote, in either direction, is getting ahead of where the actual court filings currently stand. The fifth segment is what the lower court did next, because the story did not stop with the governor's order. The three-judge federal court that had been overseeing this entire dispute since the original Robinson lawsuit responded to the Callais decision by declaring that Louisiana would be given the opportunity to enact a constitutionally compliant map right now for the election already in progress, and ordered the state to file a brief within 3 days outlining exactly how it intended to comply. 3 days. For a state to draw and defend a new congressional map in the middle of an active election, with real ballots already cast under the old one. That is an extraordinarily compressed timeline for a task that normally takes state legislatures weeks or months, complete with public hearings, expert testimony on population data, redistricting software analysis, and multiple rounds of legal review before a map ever gets finalized under ordinary circumstances. Compare that 3-day window to the process Louisiana went through the first time it drew SB 8, which involved a full special legislative session, formal committee hearings, and weeks of public input before the map that just got struck down was even passed. Nothing close to that level of process was available this time. The dissenting justices flagged this exact problem in their own writing, noting that neither the governor nor the three-judge court seemed to view themselves as limited by the fact that the Supreme Court had not even issued its official certified judgment yet under the normal 32-day process, and pointedly wrote that requiring the 2026 elections to proceed under a map already held unconstitutional was not something the dissent was proposing either, but that the speed of what replaced it deserved far more scrutiny than it received in the moment. The sixth segment is the legal argument the dissent raised about whether any of this should have been allowed to affect an election already underway, and it deserves to be presented honestly because it is a genuinely serious point, separate from whatever you think about the underlying map dispute. The dissent argued that the question of whether the Callais ruling should affect the ongoing 2026 primary is a completely different legal question from the question the court actually decided in Callais itself, which was narrowly about whether Louisiana's map violated the Equal Protection Clause. Nothing in the Callais opinion, on its own terms, resolved what should happen to an election that had already started under the old map. The dissent's position was that allowing the governor to suspend an active election and allowing a lower court to demand a new map within 3 days effectively let procedural momentum from one legal question steamroll a completely separate and serious question about the integrity of votes already cast by real people who followed every rule that existed at the time they voted. Whether you find that argument persuasive or not, it is worth understanding on its own terms, because it is the crux of why legal commentators across the political spectrum have called this sequence of events unusual, regardless of where they land on the underlying voting rights dispute. The seventh segment is what happens to a vote that gets cast in a suspended election, because this is the question everyone actually wants answered, and the honest answer requires walking through the mechanics rather than guessing. Louisiana election law, like most states, treats early and mail ballots as held securely, unopened in the case of many mail ballots, until the certified close of an election. When an election gets paused rather than completed, those ballots do not simply vanish, but their legal status depends entirely on what replaces the paused election, whether that is a rescheduled primary, under a new map where existing ballots may or may not be honored, a completely restarted voting window where voters would need to cast a fresh ballot, or a court order specifically addressing how already cast votes get treated under whatever new map eventually gets approved. Picture the difference concretely. If Louisiana's new map keeps a voter in essentially the same district they voted in originally, election officials may have a reasonable path to simply carry that vote forward once a new candidate field, if any, is settled. But if the new map shifts that voter into a different district entirely, with different candidates on the ballot than the ones they already voted for, their original ballot may not be able to count toward the new contest at all, which would functionally mean that vote has to be recast from scratch. That is the exact kind of scenario currently being fought over in filings, and it is why nobody serious is giving Louisiana voters a single, simple, universal answer right now. Louisiana's Secretary of State's office is the authoritative source for how this actually gets resolved for your specific ballot, and if you are a Louisiana voter who cast an early or mail ballot in this primary, the concrete step right now is to check the Secretary of State's official website or call their voter hotline directly, rather than relying on social media speculation, because the resolution here is a live legal and administrative process, not a settled fact yet. The eighth segment is the bigger picture beyond Louisiana, because this sequence of events did not stay contained to one state. Legal analysts tracking redistricting litigation nationally immediately began pointing to a ripple effect, and within weeks the Supreme Court allowed Alabama to use a congressional map that a lower court had previously struck down as racially discriminatory, a decision that leaned directly on the reasoning from Callais. If you live in a state with active or recent redistricting litigation, whether that is Georgia, Texas, South Carolina, or elsewhere, this sequence, a Supreme Court ruling, an accelerated judgment, and rapid state-level action to redraw maps mid-cycle, is now a template other states and other courts can point to. That does not mean it will happen exactly the same way everywhere. Every state has its own election calendar, its own emergency power statute, and its own relationship between its governor and its courts, and not every governor has the same legal authority Louisiana's governor invoked here. But the precedent of moving this fast with this little runway between a ruling and real-world consequences for an active election is now part of the national conversation in a way it simply was not before April 29, 2026. Election law scholars who spent careers studying how redistricting disputes normally unfold, typically resolved between election cycles with months or years of runway, are now openly discussing what safeguards, if any, exist to prevent this exact sequence, a court ruling colliding directly with an election already in progress, from becoming a more common tool going forward rather than the rare exception it has been until now. The ninth segment is what election officials and voting rights advocates on the ground in Louisiana have actually said about the practical chaos this created, separate from the legal arguments. Parish election officials, the local officials who actually run polling places and process mail ballots, were left managing an active election that had just been told to stop midstream, with poll workers, ballot counting timelines, and candidate filing deadlines all thrown into uncertainty within days of a ruling. Most of them had no advance warning would move this fast. Voting rights organizations that had been monitoring the Robinson and Callais litigation for years, expecting an eventual outcome but not this specific timeline, described the compressed window as leaving almost no room for orderly transition, a criticism that has come from legal observers across the ideological spectrum, not just from groups that oppose the underlying ruling on the merits. That is worth separating out clearly. You can believe the Callais decision was legally correct on the merits and still recognize that suspending an active election with 100,000 ballots already cast, on a 3-day turnaround for a replacement map, created real administrative chaos for the people whose job it is to actually run elections on the ground. The 10th segment is clearing up the myths already spreading about this story, because in the days after this happened, a lot of confused and sometimes deliberately misleading claims started circulating, and you deserve to know which parts are actually true. Myth number 1. Some people are saying the Supreme Court itself suspended the Louisiana election. That is not accurate. The Supreme Court ruled on the constitutionality of the map. It was Louisiana's governor, through a state-level emergency order, who suspended the primary, and it was a separate 3-judge federal court that set the compressed timeline for a new map. Those are 3 different institutions making 3 different decisions in rapid succession, not one single body pulling every lever. Myth number 2. Some people are claiming the 100,000 already cast votes have been thrown out entirely and voters will simply never have a say in this primary. As of right now, that is not confirmed. What is confirmed is that the legal status of those ballots is unresolved and actively being litigated, which is a very different thing from confirmed disenfranchisement, even though it understandably feels alarming either way. Myth number 3. Some people are saying this means Louisiana elections in general are now unreliable or subject to being canceled at will going forward. This was an extraordinary specific sequence tied to a live constitutional ruling about the district map itself, not a new general power for a governor to pause any election for any reason. The emergency order was explicitly tied to the Callais decision and the map dispute, not a standalone precedent for suspending elections broadly. Myth number 4. Some people are suggesting this was a partisan trick planned in advance. What the record actually shows is a genuine, years-long legal collision between 2 lawsuits pulling in opposite directions, decided by a court with justices across the ideological spectrum, 6 in the majority and 3 in dissent, with the timing driven by the court's own scheduling of oral arguments and opinions rather than by either party's political calendar. None of that means you have to agree with how it was handled. It means the honest version of this story is more complicated and more procedurally strange than either the "this was all planned" or the "nothing unusual happened here" versions circulating online. Let's step back and name what actually happened here, separate from which side of the underlying voting rights dispute you land on. A Supreme Court ruling on a map's constitutionality, a decision to bypass the court's own standard waiting period, a governor's emergency order suspending an active election, and a 3-day deadline for a brand new map. All happened within roughly 1 week, while real votes from real people were already sitting in the system. Whatever you believe about whether Louisiana's map should have included 1 majority black district or 2, the speed and sequencing of what followed the ruling is its own separate story. One about how fast an active election can be altered once a legal domino starts falling, and how little advance warning the people who already voted actually got. It is entirely possible and legally coherent to think the underlying Callais ruling was correctly decided on the merits while also thinking the way it was implemented against an active election with a rushed judgment and a 3-day map deadline deserved far more caution than it received. Those are 2 separate questions, and collapsing them into one, either fully defending everything that happened or fully condemning everything that happened, misses what actually makes this moment worth understanding carefully. If you take one thing away from this breakdown, let it be this: elections are not abstractions. They are 100,000 individual people who took time out of their day, filled out a ballot, and trusted a process that has run the same basic way for generations. When that process gets paused midstream, even for a legally serious and legitimate reason grounded in a real constitutional ruling, the people caught inside it deserve a clear, accurate account of what happened and what their options are, not a headline built to make them either panicked or dismissive, and not a video that picks a side for you before you have even heard the full timeline. Whatever comes next in Louisiana, whether that is a new map, a rescheduled primary, a fight over how the original 100,000 ballots get treated, or further appeals working their way back up through the courts, the people who understood the actual sequence of events from the beginning will be the ones who are not caught off guard by whatever the next filing says. That is what this channel exists to give you, every time a story like this breaks, with the timeline laid out plainly so you can draw your own conclusions instead of borrowing someone else's outrage. If this helped you understand what actually happened in Louisiana this spring, share it with someone who has been trying to make sense of the confusion, someone who voted early in that primary and has been left wondering what happens next. Subscribe so you get the next update the moment new filings drop, and I will see you in the next one.